Good morning, counsel.
Good morning, Mr. Chief Justice, and may it please the Court. This Court has repeatedly recognized both the potency of eyewitness identification testimony and the growing body of evidence that mistaken eyewitness ID testimony poses a serious threat to the truth-seeking function of criminal trials. In this case, the cornerstone of the Commonwealth's case against Andre Walker was out-of-court identification testimony presented through a third party, which, based on a combination of the circumstances in which the witness made his observations at the scene and the flawed way in which an identification was elicited from him 5 months later, resulted in evidence, eyewitness identification evidence, which had no probative value and should never have been provided to the jury. Nevertheless, it was provided to the jury, and the imbalance, not only was that evidence provided to the jury, but on the other side of the ledger, the trial judge either excluded or subsequently ruled inadmissible exculpatory third-party culprit evidence on grounds that that evidence was too unreliable to be submitted to the jury.
Why isn't this a blind array? The police officer did not have a suspect in mind. I know that you say that since they were all gang members, then anybody could become a suspect, but a blind array means that the person presenting the array doesn't identify this, even in his own mind, doesn't have a suspect identified. So why doesn't it meet that definition of a blind array?
Well, Your Honor, the scientific evidence in this area shows that there's a great benefit to having investigators who really have nothing to do with the case.
Okay, that's a different issue. I grant you that, and maybe that.
That's
but
the
why
blindness
isn't
issue.
this by a blind? Why isn't it a blind array? The typical definition of a blind array, at least as I understood it, was that the officer not have in mind a defendant.
Your Honor, I believe the scientific definition in the literature of a double-blind array is that the officers who are performing the ID procedure basically are not involved in the investigation of the case. They have no idea who the people are. Now, it's true, Your Honor, in this case there was not a single suspect that they were trying to push the witness to, and in that sense it didn't suffer from that particular drawback, but it was an all-suspect array.
But that seems to make sense. I mean, if the police have reason to, I mean, why do you insist on going against what seems to be logical? If the police believe it's a gang shooting, which seems all the evidence indicates it is, then why not put members of the gang in the array?
Your Honor, this is exactly why I submit the court should be serving as gatekeepers with respect to ID testimony. Because logically, I agree with Your Honor, that logically you'd say, hey, we think this is a gang case. Let's take all the members of the Franklin Hill gang, put them in an array, and see if the witness can pick somebody out. What the scientific literature tells us is when you have an all-suspect array, there's essentially there's no way to test the reliability of the procedure. If normally you have fillers. You have fillers. If somebody picks a filler, you say, okay, that person has no idea, is not able to make an accurate identification. Forget that person. But here, whoever they pick, it doesn't matter if they pick number 1 or number 7, that person becomes the targeted suspect. When you have an all-suspect array, what one court has said is the equivalent of a show-up, basically.
But you want to move the investigation forward. I don't know how many people are in a gang, but you would have to have innumerable arrays with people who, I mean, how long is their attention span if you have to put only one gang member into each array? Well,
Your Honor, you're right. It would take a lot longer. But we now know, based on a lot of scientific studies which, and I would urge, I know it's a long piece of work, but the report done by the special master of the New Jersey Supreme Court, which is printed in full in the appendix, which came out last summer, really summarizes all of the scientific evidence in this area. And the fact is that this really is scientific evidence. It totally goes against our gut feel.
But the problem that you describe, and I recognize it to be a problem, is not as to the reliability of the ID. It's as to the potential consequence of a mistaken ID. Because when you have all suspects, if the person is in error, then he's chosen somebody who has a motive to commit the crime as opposed to somebody who has nothing to do with the crime. That's the risk, but it doesn't really affect the reliability or the probability that he actually chose the right guy. It simply speaks of the potential consequences of a mistaken ID, doesn't it?
Well, I disagree respectfully, Your Honor, because I think there's no wrong answer. If it's an all suspect array, it's supposed to be a test. It's not a test. It's like whoever they pick becomes that's the guy. It's what they did in the Duke lacrosse case. It's an inappropriate. It's a scientifically inappropriate way to do it. And Justice Cowan is right. You do have to go through a time-consuming procedure to do this right. But
I mean, you're dealing with people here. The witnesses generally are not Harvard Law School professors. They have very small attention spans. They may be on drugs or alcohol. They typically are. I mean, if you're going to sit them down and say go through 30 arrays, that's almost impossible.
Well, Your Honor,
then I would think it would become suspect. At some point, they would just pick out someone just to get rid of the whole business.
I think Your Honor is raising a good point, which is if you make it overly onerous at a certain point, you can't do it anymore. But the fact is, just like with DNA evidence, just like with other kinds of evidence, if you don't do this process right, we are going to continue to bring before juries eyewitness identification, tainted evidence, which is wholly unreliable. Whether you call it suggestive or whether you call it unreliable, it is essentially garbage evidence, and it's evidence which juries are convicting people with, and that shouldn't happen.
You spent quite a bit of time in your brief using the 400 feet away. Is that in dispute?
Well, Your Honor,
I mean that would be seeing somebody that's further than the goalpost on a football field to the other goalpost. Is that clearly what the testimony presented, or
Your Honor,
is there some confusion?
There are two parts of testimony, and they're both set forth in the brief on this issue. And let me say first that the scientific evidence says that after 135 feet, you can't make out faces, let alone that this was at night from a moving car backing up. But what the record has, there's a map in the record, which is replicated, I think, at page 19 of our appendix. And based on the scale of the map, and nobody measured it, there was no evidence to the precise amount, but based on the scale, it looks like approximately 400 feet. The witness, Sylvester Harrison, testified at trial. When he was asked how far it was, he said it was about, I think he said, 3/4 of a football field. So that's less than 400 feet. That's 225 feet, but it's still a lot more than the scientific evidence says it's even possible to make out somebody's face. So that's how bad this was. It was not. So he was backing up in a moving car, hundreds of feet away at night, and then 5 months later, the police show up at his house. They show him an all-suspect array. It's not double-blind. It's simultaneous, not sequential. There's no prophylactic instructions. It has basic, and he claims that they pressured him to make what amounts to a relative judgment. And even Officer Prim testified at the hearing that it was basically, if you have to pick one, which one is it? I mean, it was basically pushing him to make a relative judgment.
But was all this before the jury?
No, Your Honor, all this was not before the jury.
I thought it was before the jury.
Did he testify that Officer Prim asked him to pick somebody who you think is the person or who most looks like the person?
Officer Prim did not testify before the jury, but the rest of this was before the jury. In other words, defense counsel did bring the circumstances of this procedure to the attention of the jury, and she argued in closing that essentially the jury should reject the identification. But obviously they didn't reject the identification. The jury specifically asked during their, I think, 4 days of deliberations for a copy of Detective Martell's report on his encounter with Harrison. And the principal difference in the case against Walker versus the case against co-defendant Johnson was that Harrison identified Walker and didn't identify Johnson. There were two cooperating witnesses with long criminal records, Boyd and Clark, who implicated both Walker and Johnson. And if the jury had believed those witnesses, presumably they would have convicted both defendants.
So what would the rule be if you prevail in future cases that involve gangs? Would the rule be that you can only have one gang member's photograph in an array? without it being challenged?
Well, Your Honor, I'm not saying it can only be one, but you cannot have an array of all suspects. Or that put it this way, Your Honor, I don't think it's appropriate to make these. I mean, and I know this Court wrestled with the same set of issues in Silva Santiago a year and a half ago, and the Court there said, well, we're not going to require this, we're not going to require that. I think what courts like to say when you're talking about identification testimony is you look at the totality of the circumstances. I think what there should be, as there is for expert evidence, as there is for when there's an issue raised about competency of witnesses, there should be a pretrial hearing at which all the circumstances are set forth, and it's not any one which per se is going to rule this kind of testimony out the window, but looking at the totality, a judge as gatekeeper, the same way a judge does as gatekeeper under Lanigan or in other contexts, or when a competency issue is raised, a judge should basically make a preliminary ruling that this evidence is so lacking in either reliability, it's because of the way it was done, that it's not appropriate for a jury to hear it. It's the same kind of balance that a court does in other, as opposed to the way we've always done it, which is, well, that all goes to the weight. We're just going to stick it in front of the jury and let them figure it out. We don't do that with expert testimony. We don't do that with witnesses who have been hypnotized before they take the stand. This Court has said, look, we don't want juries relying on inherently unreliable testimony, because that greatly increases the risks of miscarriages of justice. Let's have a screening process.
Now, haven't we already, to some extent, done that in Commonwealth versus Jones with the common law of fairness?
I think Jones is exactly the case that I think stands for the proposition I'm asking the Court to do here, which is, I think Jones said exactly that it doesn't have to be state action. That if in Jones it was an issue of suggestiveness, where the encounter was suggestive but it wasn't state action, and the Court said whether it's by state action or not by state action, it's equally unreliable. I think that's exactly the right approach, and that's the approach that should be used with respect to eyewitness identification. In this case, there should have been a challenge pre-trial to the admissibility of this identification testimony based on this totality of circumstances. Considered as a whole, both the incredibly limited glimpse this guy had at the time, the fact that he later on said he didn't make identification, all of the problems with the way in which they presented it to him, that totality of circumstances should have led a judge properly to keep this from the jury, to keep this becoming the cornerstone of a first-degree murder conviction. So I think Jones is exactly the model, Your Honor. Yes, and that, of course, Jones is common law, and it can be done under common law or under the Due Process Clause.
I take it you're not suggesting just because the witness later said, I didn't make an identification, that somehow that takes it off the table.
No, Your Honor. Frankly, none of these factors in and of themselves take it off the table. I think that's why I think this kind of an approach, a totality of the circumstances approach, I mean, all of our rules about admissibility of evidence really have to do with reliability and the screening process, so that juries don't make decisions which may well be horribly mistaken decisions based on unreliable evidence. This is an area where this kind of approach is just required. We now have enough scientific evidence. We know that bad ID testimony creates mistakes and creates unjust verdicts.
And let's talk about the rest of the testimony.
Yes, Your Honor.
Then. You had at least two, were they gang members?
Yes, well, Your Honor, yes, they were ex-gang members or gang members.
Okay, that testified as to your client's involvement in this. And there was there were other testimony as well, yes?
Your Honor, there were three witnesses. They were all people with long criminal records who were cooperating.
Who do you think you're going to get? You say that as if to denigrate the witnesses, but who are you going to get to be friends of this defendant or witness a murder?
Your Honor, I agree, and I think if the jury had convicted both defendants, I think I would not have a very persuasive argument here. The fact is, Boyd and Clark said both Johnson and Walker participated in this murder. Clark said, I think it was Clark who said he was there. He was part of it. And they both implicated both defendants, yet the jury acquitted one and convicted my guy.
But there
the
was
difference was the Harrison identification.
But there was other evidence apart from that. I mean, there was one person said that another person went into the car, into the Toyota, which wasn't.
That's correct, Your Honor. And that was another, but that was many hours earlier. I think that witness said at 4:30 in the afternoon he saw my client and another individual get into that car. So that's some 3.5 to 4 hours before
And
the
you
killing.
also had your client living in the place where the drugs were stored, and with the suggestion that he was the enforcer based on the previous episode.
Well, Your Honor, I submit that there was no evidence that this case had anything to do with drugs. This supposedly was a retaliation of one gang against another gang. There were a series of shootings and assaults over a period of weeks. This was not, but yes, there was some other evidence. I mean, as in any case, I'm not saying that it was that it was precisely the same against both defendants. But
Clark testified that the defendant was speaking to him about the shooting the next day. And Boyd said that the defendant gave him the details of the murder, and Dotson said that the defendant had asked him for the car that day.
That's correct, Your Honor. Those are the three
defendant
witnesses.
was driving the car. Okay, so there's substantial other evidence against your defendant.
There is, but as I said, Boyd and Clark also said that Johnson committed the crime, and the jury acquitted him. So, I mean, it's always hard to try to, we were all trying to read the jury's minds and what they relied on. Surely we cannot say that the jury probably would have reached the same result but for Harrison's ID. I don't think you can say that. I mean, maybe they would have, maybe they wouldn't have, but Harrison's ID was clearly the critical difference, and it was relied on extensively and improperly by the Commonwealth in closing, where in closing the Commonwealth argued that Harrison told us he got a good look at Walker and he got a good look at the perpetrator, where Harrison said exactly the opposite, and the DA said in closing that Harrison told us that the person looked like Andre Walker, where Harrison on the stand said he had never seen either defendant before in his life. So it was exploited by the district attorney. It was also exploited by the district attorney in terms of the way they put the third-party evidence in through Detective Martell. They went beyond the mere identification, which I think is what this court said is all they get in under Duke Lee, and rather they got in a lot more of what Harrison supposedly said on that occasion. So this was critical evidence to the Commonwealth against Walker. And if the court agrees that this ID evidence should not have come in, I just don't think there's any reasonable argument that it was harmless.
Now, in your reply brief, you say counsel could have had the benefits of Harrison saying in front of the jury, that's not, I've never seen that man before, pointing to your client, and all of the information which he says suggests that the police were trying to have, that because of this mistaken ID, they had the other people target him. I mean, that, I guess, was the defense strategy. You say he could have had that without the ID?
Well, Your Honor, I think I said he could have the latter but not the former. In other words, I think certainly he could have put in under Bowden and Reynolds and those kinds of cases that these officers went to see Harrison and they pressured him and pressured him and pressured him to make an ID. I think that the fact that the police were overbearing and inappropriate.
But then once you do that, certainly the Commonwealth is going to get in that when he was pressured, or however you want to put it, he then picked out this defendant. I mean,
well, I don't think so, Your Honor. I don't think
you mean
that
you can
opens,
open the door and the Commonwealth can't walk in it and then put in the rest of it? I mean, that's
I don't think so, Your
grossly
Honor.
unfair.
I think the issue, I think they would be able to put in testimony from the officers that no, we didn't pressure him. He was not intoxicated. We were polite to him and courteous to him. But I think that, look, if the fact of the ID had come out, if that was out of the case, obviously, as even defense counsel, as even trial counsel admitted at the hearing, there would have been a much better chance of an acquittal. So whether you could have, how close to the line you could have pushed it,
But I thought
I'm
part
not
of the
sure.
strategy was to try to tell the jury why these two co-conspirators were, of all the people in that gang, saying that it was your client who had done the shooting. And I had thought part of the strategy was they got this mistaken ID. And then they began to press everybody else to say he's the guy, and that's why these accomplices or these gang members of all the people in the gang were saying it was your client. I mean, wasn't that part of the defense
Your Honor,
strategy?
that might have been a reasonable strategy if Harrison had picked both defendants out. But since he only picked out my defendant, that really wasn't a reasonable strategy. I mean, I can't. It was manifestly unreasonable to not try to keep out the testimony from the only non-criminal eyewitness with no axe to grind who had supposedly identified my guy as the perpetrator. Thank you, Your Honor.
Thank you.
Good morning, Your Honors. May it please the Court, Kathleen Celio on behalf of the Commonwealth. I ask this Court to affirm the defendant's convictions and to also affirm the motion judge's denial of the defendant's motion for new trial. I'll just first start off. Sylvester Harrison, was not the key to the Commonwealth's case. If you look at the Commonwealth's closing argument, it spans 35 pages. He talks 2 pages about Sylvester Harrison's ID, and it has to do with the fact that it corroborates Sherrod Clark. The prosecutor stands up and says Sherrod Clark is the most important witness here. And Harrison's identification just corroborated that. And so our case was premised on that. And I think that if you look at defense counsel, I think Harrison was the key to defense counsel's whole case. And I think it was reasonable, looking back in 2004, 2005, of whether to suppress this identification or to have Harrison, who got on the stand and pointed at both defendants and said, I'd never seen them before, that implicated the police in coercion, in suggestion, which was the whole case she was built around. And I think if you look at that, just the first prong of whether or not this was a strategic was manifestly unreasonable. That counsel 3 years later said, it might have been better when your client has been convicted. I don't think is probative of the fact that 2004 and 2005, leading up to the case, whether or not the decision to put on Sylvester Harrison and to have such probative evidence for the defendant in which you built a case around was manifestly unreasonable. And I don't think so. And as the motion judge found, I don't think that this motion to suppress would have been allowed anyway. There was nothing in this array.
If it were brought today, would it have been allowed? I mean, should we consider, let's fast forward to 2011. How should we measure and judge an identification in these circumstances?
No, I don't think so. What you had is a 12-person array. Everybody looked the same. The witness, this is very different than the Duke lacrosse, most respectfully, because
so there were 12 suspects. So there was no one in there, no test case. Clearly, if someone was picked out that had nothing to do with this, lived in Springfield or something, there was no ability to sort of test that.
Correct, but I don't think that by putting in 12 individuals that look the same. I mean, obviously, with the jurisprudence that this court has had in Silva Santiago, the instructions given to the witness would have been very different than what was given. And, Detective Martel testified that BPD now shows them sequentially. They follow the DOJ regulations. This court recognized that in Watson. So, I mean, it's hard to analyze it now with all the measures that this court has required of an identification.
Okay.
That then having 12 individuals that are Detective Martel testified, they were associated with the Franklin Hill Giants. It wasn't all of the Franklin Hill Giants.
The motion for new trial judge was the same as the trial judge, Judge Broussard.
That is correct, Your Honor.
And he made the ruling that a motion to suppress would not have made a difference in the case.
That is
right?
correct.
So he would have been presumably the one ruling on it. Supposedly all judges would apply the same factors. But
right.
So he makes the ruling that it wouldn't, the motion to suppress would not have succeeded.
That is correct. And key to
it wouldn't have made a difference in the trial.
Correct. He said both things. And I think that looking at it, what he did do as the trial judge is he heard Sylvester Harrison's testimony and then heard Martel's and Prim's in the motion for new trial, heard Martel's at trial. And he found on page 353 of the defendant's record appendix, on page 110 of Judge Broussard's findings, that the defendant didn't meet his burden in showing that Harrison was drunk, that there was any coercion, or that he had told him that there was a gang. So what you have here is based on what Prim testified, that he showed Harrison 12 individuals. He said, do you know any of them, either because they're in the neighborhood or because they may have been related to the event that you just recounted? And I think that in this court's jurisprudence on identification, the court has always looked at not necessarily whether some witness was mistaken, but whether that was a product of suggestion. And still in Jones, even though the common law, there still is the idea of suggestion, that something caused an individual to be singled out, that something made it, the person become, I guess, stand out, or that the police, and that's irrespective of what the police do. But here you have 12 individuals. Look at the defendant's record appendix, page 21. There is the 12 individuals there. They have similar features. They look very similar. And I think that the way that in the judge's credibility in finding that, you know, Harrison wasn't coerced, he wasn't said if, both Martel and Prim were both testified to that. That he was never pressured in that way, as Harrison testified.
Why wasn't it? Oh, go
ahead.
Are you on the same subject? Go ahead.
Yeah. Should counsel has suggested that judges should also be testing for reliability before eyewitness testimony is admitted. Reliability should be looked at, and where you have someone at night making a very uncertain identification from 400 feet away after a second or two of view, that just is inherently unreliable.
No, I don't think so. This court has already rejected the reliability, and I understand that he's trying to say that it should adopt a reliability test if it's not suggestive, which is a little bit different than the court's ruling in Johnson. But I think that what it really does hinder is a situation like this, where you have a recanting witness who made a prior identification, because of course at trial he's going to make the situation be unreliable. You know, I mean, he's going to testify that he couldn't see it, you know, that he was far away. You know, I mean, that was his whole premise, was the police coerced me into making an identification, and that I couldn't see anyone. And so, of course, all the facts that he testified to made it unreliable, and that's what the defendant's relying on now, because he wanted the jury to know that he had no part of it.
Well, why should we take part of his testimony as unreliable and the other part as reliable?
Well, this court in Conduct Lee said that even this court allowed in prior identification of a recanting witness, and it's for the jury to decide. I mean, this was before the jury, and I think that in the jury question and looking at wanting Detective Martel's report is because that was the focus of defense counsel's whole premise, is trying to find out if Martel really did coerce the defendant. I mean, I don't think.
How do we explain? I mean, you say that the Harrison identification was not key to the case. It may have not have been the hub, but how do we explain the different verdicts then? I mean, isn't Harrison's identification, or at least the testimony about that identification, the swing?
I disagree with that. I mean, if you look at all the evidence, we had much stronger evidence against the defendant than against Johnson. And in fact, a lot of the drug evidence was introduced to show Johnson's motive, because we had troopers testify that they saw Johnson selling drugs, was related, had some association with Richard Green, who was shot. And so I think that I don't think that it was just the identification, nor can this court try to read the tea leaves of a jury, which is, very difficult in this situation. But the case was much stronger against the defendant.
Could you address yourself to why wasn't there an alibi instruction here?
One is because it is not required.
No, he still could have committed the murder and been at the apartment later or before or whatever. But that's not a reason for not giving an alibi instruction.
No, but I think then in looking at it, this court has never required it, and I think that all it is it has required that the judge makes clear that the defendant was, that the Commonwealth proved beyond a reasonable doubt that the defendant was at the scene and committed the crime. And I think, that the judge in his joint venture instruction, clearly established to the jury that they had to find that he was at the scene and participated in the murder for them to have found the defendant as a joint venture in the murder.
If we were to view the evidence in the light most favorable to the prosecution, how far away was Harrison from the shooting?
It's unclear. It's unclear because we couldn't get in. Harrison tried to separate himself and say that he was far away in his testimony, and then we couldn't get in a lot of the details of how far he was in his statement to the police, because that wasn't part of the statement of identification. So it's really hard to tell on this evidence.
Well, we have to go on the evidence that's in the record, and from what's in the record, is the closest that you can get 225 feet?
I'm not quite sure, but I guess this goes to my larger point of the defendant's asking you to consider Harrison's testimony as indicia of the reliability of it, when all he was trying to do is show how not reliable it was.
Of course, if there had been a motion to suppress, what he said at the earlier ID would have come in.
Correct.
To evaluate the reliability of the ID.
Correct.
You couldn't get it in a trial because
Right.
of the limitations on lay.
But that was never asked of actually at the motion for new trial. That was not established at the motion for new trial. The defendant did.
So even there, we don't know how far away.
Correct.
What is the Commonwealth's best evidence that the defendant tried to murder Estacio?
Well, if you look at a couple things, looking at the exhibits, especially 31 and 32 and 33, 33 sketches out all of a sketch of where the shell casings were, where the van was, where the victim was lying. And if you see there, one is based on Sherrod Clark's testimony, Johnson was the person who first fired the shots, and that it hit Estacio and it hit the victim. And then the defendant got out of the car and started shooting. Detective Martel at trial testified that Sylvester Harrison said that the defendant came out of the car and started shooting at the two people on the sidewalk. So we have that evidence. We also, him coming out and shooting at the victim, it's part and parcel. Estacio, the location of the van was near the location of the victim. Just looking at those exhibits, it helps elucidate the testimony that Estacio was very near the victim at that time.
You mean because Estacio was under the van and the van was near the victim?
Correct.
And the defendant was seen shooting shots at the ground?
Towards the ground.
Now, do I gather you agree with the defendant that there was no joint venture instruction?
Yes, there was no joint venture instruction, and in fact, Judge Broussard went so far as only going on the attempted battery theory of assault. And that Johnson was tried and charged with assault and battery on Estacio. So that was our theory.
But purely as a principle, there was no claim that he was a joint venturer with regard to that.
Correct. That was discussed. If you look at, I think it's transcript 10. I don't know what day it is, but we didn't proceed in that manner, and he was not instructed. And the judge made it very clear that the joint venture instruction only dealt with the murder. And if this court has no further questions, the Commonwealth will rely on its brief.
Thank you.
Thank you.